Hello everyone, welcome to the Dialogue on Construction Law. Today, myself Nikhil Ramdev, Senior Associate at MRP Advisory. Today we have very special guest with us. I am excited to introduce Mr. Aniruddha Kumar, Senior Vice President and Head of Business Development uh, and Tendering at Kalpataru Projects International. Thank you so much, sir, for taking out time from your busy schedule and being with us today to discuss the recent policy issued by Government of India on mediation and arbitration. Before we divulge to the topic, can you please briefly introduce yourself?
Yeah, good afternoon, everyone. I'm basically a civil engineer by profession and having the master degree in construction management from NICMAR and consultancy management from BITS Planning. I have 30 years of experience in the field of contract management, arbitration claims, tendering, business development, and project management. And I have worked in various sectors, including railway, metro, airports, irrigation, hydropower, thermal power, roads and highways, and buildings and factories and institutional projects. And in past, I have dealt more than 50 clients spanning through different public sectors, state government departments, state PSUs, private bodies, international government, and private clients. So right now, I'm working as the head of business development tendering with the Kalpataru Projects International Limited in railway and metro sector.
Thank you, sir. So, in follow-up to that, can you please tell us what the services that your company provides? Also, are there any policies in your companies relating to arbitration and mediation which you follow?
So basically, Kalpataru Projects International Limited, earlier its name was Kalpataru Power Transmission. It was established in 1981. And it's a global engineering, procurement, and construction EPC company having footprints in more than 73 countries. And we are primarily into power transmission, distribution, building and factories, roads and highways, water, irrigation, railways, metro, oil and gas, different segments. And we are having consolidated turnover of last year 2.2 billion US dollar and having an order book of 7 billion US dollar. And in the railway segment, we are a leading player in the railway construction in overhead electrification, track laying, signaling, telecommunication, power system, and the traction system. And into metro, we are doing the basically elevated and underground works along with the electrification, third rail DC system, and the rigid overhead cutlery system. So as far as the policy of our company related to this, it depends mainly on the different factors like what type of dispute and what type of client and the amount involved. So as such, we don't have any fixed policy, but we try to just conclude the dispute through mediation or through amicable settlement instead of going to the arbitration or through the litigation process.
Thank you so much. Now I'll move to the topic in discussion. As you are aware, recently Government of India has issued certain guidelines which says that meet sorry certain guidelines which recommend use of mediation over arbitration for disputes worth more than 10 crores in domestic procurement. So, what is your take on that policy?
Yeah, basically, let me brief you what earlier it was happening because in case of arbitration, the arbitration earlier just to resolve the disputes. The arbitration process was involved because it was the speedy resolution process, less formal, and decision making was fast and final decision making under the Arbitration Conciliation Act. And there was very limited scope for the challenge in the court. So, but later on, that government is when government observed, then in most of the cases when adverse award comes and government go to the judicial process and officers are transferred from one place to another place, and even new officer doesn't have the deep knowledge. So government decided that they should change this policy and they should come with some system where they can be faster or speedy resolution process of the dispute. So government came with this new guidelines in June this year only, and in which basically they just try that restrict the arbitration process as a routine process, because earlier what was happening in almost all the contract arbitration was in a routine, a clause, and all the dispute has to be resolved through the arbitration. So through this policy, through this new policy, government wants to restrict the arbitration process, and they want that any contract having more than 10 crore rupees, they should be settled through mediation or amicable settlement. And they want to prefer the institutional arbitration. And because under this policy, government wants that arbitration should be invoked only when there's a high chances of the winning. Otherwise, they should try to be through mediation settle the dispute. And they want to encourage that this Mediation Act 2023, which was came in place last year. So through this Mediation Act, they want to adopt that all the disputes should be resolved through mediation in a speedy manner and amicably settled, so it can basically reduce the number of litigation cases.
Thank you for the insights. So I'll move on to the next question. So what do you think as how will this shift impact the drafting and negotiation of construction contracts?
So basically, after this new policy, now you have to be more vigilant when you are drafting or negotiating a contract, because you have to see that in most of the cases now, government will just remove this arbitration clause, and they will introduce a new dispute resolution mechanism, which is through resolution. And in case of resolution, so you have to be careful, and that when you are negotiating a contract, and once you accepted that regulation and you signed a settlement agreement, then so then there are little chances, or there are very less chances of taking that settlement agreement, because once you have accepted, then you cannot take it to the court. So basically, when you are negotiating a contract, and you are drafting a contract, so you have to be careful, and you have to see all these things, because then there will be lesser chances for taking any dispute to the arbitration matter.
Thank you for this interesting thought, sir. Uh, so my next question is, how do you see this shift affecting the overall dispute resolution landscape in the industry?
So basically, if you would see the new policy, which is mainly focusing on the mediation, so if it is implemented in a proper way and in the right spirit, then definitely it will reduce the backlog of the cases related to the arbitration. Because what was happening, most of the arbitration cases, when adverse award was coming against the government, so all the officers, they were taking this to the next level, to the court. So through mediation, so if it is implemented in the right spirit, so the less litigation cases will happen, and the time in the resolution of the dispute shall be lesser, and that will have a less cost, because arbitration process was little lengthy and the costly one also, and ultimately it was leading to the court cases. So through mediation, if this is implemented in the right spirit, then definitely. But there are certain this disadvantages also of this shift, this new policy. Number one, that because it will require this settlement agreement to be approved by the high rank officials, or high level committee, any dispute having the high value on stake. So in this case, that there will be more bureaucratic delays, and there will be complicated contract negotiations and execution. So, and second thing, that in a high value contract may face uncertainty due to stringent condition under this arbitration can be invoked. So possibly leading to the agitation in the large scale investment. So this new policy, because everyone will see in a different angle, because when the arbitration has been removed, and or it has been restricted for a dispute having more than 10 crore rupees. So then large value contract or large value disputes, so the party, so they will also be that they will have now limited options after this policy here. Yes.
Thank you, sir. You have given us a lot to think about. Moving further, how is your company adapting to this policy shift?
So basically, this although Mediation Act has came last year, but this new guidelines this came just in June month, so just 2 months ago. So we have to see that how these guidelines are adopted at a ground level with the client. So still, my company that is understanding the implementation part of these guidelines at a ground level by the government officer, and in due course we shall make a strategy and we shall strategize ourselves with respect to the new guidelines that how we should adapt to this new guidelines.
Thank you, sir. That is great. So, looking forward, how do you foresee the long-term implications of this policy shift in the construction sector?
So basically, this government has a good intention to streamline the dispute resolution mechanism for a speedy and fair decision making. But in long term, the true impact of new guidelines remains to be seen. Their success basically will depend on the implementation, a change in the government mindset, and the response of the legal community and businesses. So it will be difficult to say right now because they are both type of views are coming. But it may be that if it is not implemented in the right way and not this, the government mindset or government officers mindset to change, so then it will become an additional complex layer before taking the matter to the court. So I think if it is implemented in the right way with the transparency, with the accountability, then definitely it will have a positive impact in a longer term.
Thank you so much, sir, for joining us today and sharing a valuable insights and expert perspective on this topic. Thank you, sir.